can do that. Hello and welcome. I'm Adam Liptak. I cover the Supreme Court for the New York Times, and we're here today to hear about the upcoming term, which is studded with interesting cases. We have a fabulous panel to discuss it. You will hear many insights, which I've been instructed you should tweet with the hashtag fedsocevents. We are going to follow the panel discussion format handed down to us from the founding generation, a series of short presentations, a little interaction among the panelists, some questions from me, and then lots of questions from you. So as you hear things that you think are provocative or misguided or wrong, make a note and ask a question in a little bit. With us here today are Gail Heriot, who's a law professor at the University of San Diego and a member of the United States Commission on Civil Rights. John Elwood, a partner at Vincent & Elkins, a former clerk to Justice Kennedy, and the author, for our purposes, most notably of the SCOTUS blog, Realist Watch, which is, and although there's not a lot of competition, the funniest thing on SCOTUS blog. And really worth reading by any standard, not so much for the content, but for the humor, Come for the content, stay for the humor. Neil Katyal is a partner at Hogan Lovells, a law professor at Georgetown, a former acting United States Solicitor General, a former law clerk to Justice Breyer. John Stiniford is a former prosecutor and now a law professor at the University of Florida, and Ed Whelan is the president of the Ethics and Public Policy Center, but for our purposes, most notably, a very vigorous blogger at the National Review Online's Bench Memos. My colleagues and I think any day that Ed does not write about us is a good day. So we're going to start. I think the consensus is that there are three marquee cases so far. There will be more. But on the docket so far are cases on affirmative action, voting rights, and public unions. And I think we'll mostly start with those, with Gail handling a couple of them to kick us off. Do you want me to go? We were thinking we'd sit. We were thinking it would be a little less formal.
I will absolutely sit, but I've only got 7 minutes to get through this, so I'm going to talk really, really fast. I've been asked to discuss two cases, Fisher versus University of Texas and Evenwel versus Abbott, both out of Texas. This is Fisher's second trip to the Supreme Court. Evenwel, on the other hand, is kind of on a fast track. It was direct appeal from a three-judge panel. Interestingly, same attorneys represent the petitioners' appellants in both cases. Let's do Fisher first. Back in 2003, when the court decided the twin University of Michigan cases, Grutter versus Bollinger and Gratz versus Bollinger, the media reported the cases as kind of a tie, but it was not a tie. Let me emphasize that. The Grutter 5-4 loss was devastating for race-neutral advocates. Their victory in Gratz was trivial, at least as that case has been interpreted, easily worked around by colleges and universities. We're still kind of digging out of those two cases. The Grutter court held, as it had to, that strict scrutiny applies to discrimination against whites and Asians just as it does to discrimination against other races. But it turned around and deferred to the University of Michigan on the question of whether diversity is a compelling purpose, and ultimately upheld Michigan's admissions policies without a lot more in the way of analysis. Now let's pause and take in the importance of that last sentence there. Everyone on the court agreed in Grutter that the application of strict scrutiny was required, but the majority deferred to the judgment of a state agency on racist discrimination. Now imagine if a court had deferred to the judgment of Kansas City schools in Brown versus Board of Education. Don't think for a moment that there were not at the time educators galore who would have sincerely thought that segregation was in the educational interest of all concerned. Deferential strict scrutiny is not strict scrutiny. It is a contradiction of terms. Whatever you think of the policy revolt in that case, Grutter left the strict scrutiny doctrine in disarray. One more interesting footnote to that case, Justice Sandra Day O'Connor went on in Grutter to predict that universities would no longer need race preferential admissions policies in 25 years. Note that in December, when this case is going to be argued, we will be halfway through that period. Yet, largely as a result of Grutter, if anything, race preferences are larger than they were. Most troubling of all, the higher education industry ignores the growing body of empirical evidence indicating that preferential treatment does more harm than good, even to its intended beneficiaries. Okay, so now here we are. The University of Texas is one of those universities that expanded its race preferential admissions policies post-Grutter. Pre-Grutter, in response to a Fifth Circuit decision that was later overruled in Grutter itself, it had eliminated preferences entirely, and instead the state legislature had established a system under which the top 10% of graduates of every Texas high school could get into UT regardless of their SAT score. And at the time, UT was bragging that it had achieved all the diversity that it needed. Then after Grutter, it changed its policy to reestablish preferences for African Americans and Hispanics. Now, some hoped that Fisher 1 would start the long process of establishing race neutrality as a bedrock principle again. And maybe it did. That's the point here. With Fisher 2, we're going to find out a lot more about how serious the court was just a little while ago in deciding Fisher 1. In a 6-2 opinion, in Fisher 1, the court held that deference applies only to the compelling purpose part of the strict scrutiny analysis and not to the narrow tailoring part. Fine, but the question now is, how strict is that strict scrutiny going to be in analyzing the narrow tailoring of the University of Texas's case? Fisher 1 had remanded to the Fifth Circuit to apply that serious strict scrutiny standard to the narrow tailoring, but the Fifth Circuit just coughed up the same result. UT's policy was narrowly tailored as far as the Fifth Circuit was concerned. It appears the Supreme Court may disagree or may simply want to add some more. We're going to have to wait and see on that. One of the great curiosities of litigation over affirmative action is that many academics agree that it's not really about the pedagogical benefits of diversity, conferring those benefits on all students. Yet that's the only purpose that it's clear that in Bouaphakeo and in Grutter, the court was willing to approve. It may really be about something completely different. It may really be about someone's conception of what racial justice should be, or simply the practicality of increasing the size of the African American and Hispanic professional class. The closer one looks at the University of Texas's actual policies, the less they seem to be geared towards capturing the pedagogical benefits of diversity for all students, or at least that's my perception. We'll find out by June if a majority on the court shares my perception. Let me switch to Evenwel. Briefly, Evenwel is about how the Texas state legislative districts are drawn. Should the number that we consider be the number of persons in each district? Should they be equalized? Or should it be the number of eligible voters? Put differently, when the court in Baker versus Carr or Reynolds versus Sims, cases that every law student studies, in law school, when they used that term, one person, one vote, did they mean it, or did they mean an equal number of persons in each district? The distinction didn't matter so much back in the 1960s when the number of non-citizens living in this country was at a low, but it makes a huge difference in Texas and in many other states today. Urban districts get much higher representation in state legislatures than they would if only citizens or only eligible voters or only registered voters were counted. Lots of non-citizen immigrants live in urban neighborhoods. Interestingly, the Texas Constitution once required that legislative districts be drawn according to qualified electors. That was the constitutional language, that is, eligible voters. But during the 1980s, a Democratic Texas Attorney General issued an opinion that Reynolds versus Sims required all persons instead. And the Texas Constitution was eventually amended to use the all persons standard instead. That was probably a legal error. Texas isn't even arguing that its method is required. The two positions taken in Evenwel are whether, one, a state must use qualified voters, or at least citizens as its baseline measurement. And this is appellant's position, the one man, one vote means what it says argument. Or alternatively, a state may choose to draw its districts that equalize either total population, total citizen population, total eligible voting population, et cetera. This is the position of Texas and of the three-judge panel, which essentially said it wasn't going to wade into this political thicket, to use Frankfurter's language from Colgrove versus Green. Part of the problem here is political philosophy. What's being represented here? Are the voters in the district, are they representing themselves, their children, their neighbors as well? Part of it's practicality. All persons is easy to get from the census. Getting citizen versus non-citizen is not so easy. On the other hand, getting eligible voters is doable. So those are questions that the court's going to have to wrestle with. And I think my time's expired.
Thank you so much for that brisk presentation. Before we move off of Fisher, I wanted to give maybe Neil a chance to respond and ask you, Neil, the question of, doesn't Gail have a point that it's a little hard to know how to apply strict scrutiny to a holistic admissions process that's fuzzy by design?
Yeah, no, I think, Gail, thanks for the presentation. I think this is a very, I'm recused from this case because I had it in some capacity earlier, but I think it's a very tough case for the university. And one of the things I like so much about Gail's remarks is a lot of people are talking about, well, Justice Kennedy and his kind of heartfelt views about race neutrality. And what Gail is picking up is something different in a different strand of the court's jurisprudence, which, at least in the Roberts court, as opposed to the O'Connor court, is an anti-deference kind of view, a view that, experts shouldn't always be trusted. I think you saw it very clearly in a decision I happen to like, I suspect many of you won't in this room, which is the Affordable Care Act decision last year, in which the Chief Justice went out of his way to say, I'm not deferring to the IRS on such a decision of such gravity. I suspect that Gail is right, that, to the extent the university loses this case, I think that it won't just be on race neutrality grounds, but on this kind of suspicion about expert opinion.
John's going to tell us.
Can I just say one thing about what Neil has said? I'm very nervous about this notion of Fisher 1 making a distinction between deference on the compelling interest side and not on the narrow tailoring side, because I don't think it's easy to draw the border here. Just to take a case out of history, Korematsu, because it's easy to make the point with this, was the so-called compelling interest there. I'm not making a comment on whether Korematsu is well decided or not, but was it?
Oh, come on, go out on a limb
there. Is the compelling interest national security, in which case all the work is going to be done by the narrow tailoring side of the analysis? Or is the compelling interest, you put it very specifically, say the compelling interest is the need to remove Japanese Americans from coastal areas because of, you can get very, very specific, in which case, sure, it's narrowly tailored. The more you put on the compelling interest side, the less you're going to put on the narrow tailoring side. And so now we've got law that says we have to make this strong distinction between those. And I don't know that it's possible.
And it's true that the Fisher's latest merits brief does take aim at the interest, saying that you can't know what to narrowly tailor to unless you have a very precise definition of the interest. But time is short. We're going to move on. John's going to tell us about the third marquee case involving public unions and some other things as well.
So in many ways, this is a term of sequels. Fisher is one of those cases that's a sequel, and I'll be handling several of the other sequel A, or whatever the term would be. Friedrichs versus California Teachers Association, which is a First Amendment challenge to California's agency shop law, requiring public school teachers either to be union members and thus pay union dues, or contribute an equivalent fee to the teachers' union. This is based on the court's decision in the year that ABBA released its hit Dancing Queen, meaning a long time ago in 1977, don't act like you didn't know, where they held that a public sector union can bill non-members for expenses related to collective bargaining. The idea was to keep non-members from free riding on the efforts of the union on their behalf. But under Abood, unions may not require members to fund political or ideological efforts. Now, as probably everybody in the room knows, and Knox versus Service Employees International Union in 2012, and again in Harris versus Quinn in 2014. Justice Alito, writing for the 5 most conservative justices, wrote that compulsory fees for collective bargaining constitutes a form of compelled speech and association that infringes First Amendment rights, and it called the court's past tolerance of the practice an anomaly, which is not what you want to see if you're trying to defend it. Because a majority of the court has expressed skepticism, I think most people expect that Abood is going to be overruled, and that is what the first question presented and the Friedrichs petition asks. This court has a very broad view of free speech, and this is a subject about which the court's remaining swing vote doesn't swing very much. On the other hand, why didn't they do it already in Harris versus Quinn? It's a funny thing. There's more of a kind of an extended throat-clearing period in this than there is in some past cases. So the question is whether they'll come up short. As a fallback, the petition asks a second question that strikes me as very likely to prevail, which is whether it violates the First Amendment to require public employees to affirmatively opt out of subsidizing non-collective bargaining speech, that is politicking stuff, whether it violates the First Amendment to make them opt out, as opposed to requiring unions to make everybody opt in if they feel like supporting that. And as I say, that strikes me as a likely win for Friedrichs. Because the case was decided on the pleadings, respondents argue that there isn't enough record to decide this case really. There's also the question of what role stare decisis will play, because a lot of people thought that Basic versus Levinson might be overruled a couple terms ago in the Halliburton case, and the court didn't. So the court is still capable of surprising us, perhaps a little bit too much. If the court invalidates Abood, it would have enormous implications. Public sector unionism is one of the few bright spots in unionism in the United States. And if you can get whatever benefits the union gives you without paying the dues, obviously it's going to decrease union membership, and without the money, they're going to have a lot less influence. This case has a real potential to be a watershed in labor law. I have joked that I get 9/10 of a cent anytime anyone says the phrase, the Citizens United of Labor Law. I don't actually. That may surprise you, but go ahead and say it anyway. This court has gotten an assist late in the game by David Frederick, has joined the case, who's a repeat player from Kellogg Huber, my wife's firm. The other half of what I want to talk about is class actions, and it's going to be a big term for class actions. There are 3 big cases in front of the court right now, and several of them are sequels. On a whole, the court takes a pretty dim view, or at least the 5 most conservative justices take a dim view of class actions. Think Walmart and Comcast versus Barron's, and Genesis Healthcare versus Simzik in the last few terms. The first case I want to discuss, definitely one of the sequels, is Tyson Foods versus Bouaphakeo, which I've actually written out phonetically, so I don't have to struggle over how you read that Thai name. It's an overtime case stemming from allegedly uncompensated overtime putting on and taking off protective clothing and equipment at a pork processing plant. And it raises 2 questions that arise all the time in class actions. It arises so frequently there were, I think, 4 other cases pending at the time that this was taken, all raising these questions. Number 1 is whether damages for class members can be determined using statistical sampling. And secondly, whether a class may be certified or maintained that contains members who were not injured. The law, as I say, is generally favorable to Walmart versus Dukes, but unlike the Walmart case, which involved a nationwide class action and a much better claim that there were going to be people who were not, that the class mechanism didn't work really well, this is a single plant in Iowa. And so I think it's in some ways a tougher road for the business here. On the other side of the equation, there's a 70-year-old Frank Murphy opinion for the court, which involves not that dissimilar of a situation, so I'll be citing that. And this is another case where they brought in heavy hitters late in the game with Eric Schnapper, the academic labor lawyer from the University of Washington, and also David Frederick, who has one of those other cases that is being held for this. That involves, I think, maybe the largest class action judgment in American history. One interesting thing here, the class lawyers are attempting to peel off votes of a natural supporter, Justice Scalia, by invoking San Francisco versus Sheehan last year. Recall that was a case that invoked a split, and then San Francisco didn't actually want to defend one end of the split. And the respondents here, the class members, argue with some cause that Tyson's is engaged in bait and switch by arguing that you couldn't even have Article III standing to have injured people in a class, and now they're backpedaling from that and saying you can't give damages based on that, and you have to have a mechanism to get them out of the class, which is a slightly different argument. Second case is Spokeo versus Robbins. Which involves Robbins. He claims he was injured by Spokeo, which operates a people search engine that aggregates publicly available information. Spokeo's information wrongly depicted Robbins as older, married, more educated, and wealthier than he is, which is the joke that I made in my Cato piece is that previously, before the internet age, that was what class reunions were for. But he actually has it's easy to make fun of him, but he has an argument that he is actually injured by this because when it looks like that, he can't apply for entry-level jobs and he is hard up for a job. People will say he's overqualified. The question presented is framed by Spokeo, and that's a gross oversimplification, but I got 7 minutes. Spokeo says the question is whether Congress may confer Article III standing upon a plaintiff who suffers no concrete harm by authorizing a private right of action based on the bare violation of a federal statute, which here is the Federal Fair Credit Reporting Act. This is another sequel. It's a sequel of First American Financial versus Edwards, which was October term 2011's longest pending case at 213 days. And the court on the last day of term dismissed it as improvidently granted. So obviously, this is a hard issue. I could have told you that even without the fact that they dismiss as improvidently granted. But so this is going to be a tough one to call which way that's going to come out. I will say that this case has a more sympathetic plaintiff, I think, than the First American case because it's easier to come up with, in my view at least, to come up with a theory under which he was harmed in a conventional sense. And the SG says this is basically not that different from defamation law. Third case is Campbell-Ewald versus Gomez. Campbell-Ewald is a U.S. Navy private contractor that sent a recruiting text to 150,000 cell phones, and one recipient commenced suit under the Telephone Consumer Protection Act. Campbell-Ewald offered to pay the guy $1,503, which is as much as he could have recovered if he prevailed at trial, and also to refrain from texting him in the future so he got all of the relief to which he was entitled. And they said that mooted the case. This case presents the question, plus a derivative sovereign immunity claim, which is much lower profile. Two questions presented. The first is whether a case becomes moot when the plaintiff receives an offer of complete relief of his claim. And secondly, whether a case becomes moot when the plaintiff has asserted a class claim, because he does insert a class claim, but receives an offer of complete relief for himself before any class is certified. And this is a sequel to Genesis Healthcare versus Simsek, which sought to resolve the first issue, but it turned out that the plaintiff in that case, respondent there, had conceded that in the Court of Appeals, and so the court didn't get to it, and they just assumed it away. The court's four liberals are filed a strong opinion. Justice Kagan wrote it. It's noteworthy. It's worth a read. And they have definitely staked out very strongly the position that an unaccepted offer can never moot a case, noting in part that Rule 68 of the federal rules says an unaccepted offer is considered withdrawn. Judge Easterbrook in August managed to reverse prior precedent in the Seventh Circuit and adopted this position also quite strongly. And I think that every court of appeals that has decided the case since that Genesis Healthcare case has sided with the dissent. And so the four liberals are already very much on the record for that issue, and the only question is whether this famously disciplined group, gesturing to Mr. Liptak, can just peel off a single conservative vote. And I say that the odds of that are probably fairly decent. I will say that I think that this case is less sympathetic to Simzak because it sounds a lot more opportunistic, whereas the the respondent in Simzak was a woman who was, she looked an awful lot like she was being cheated out of her overtime when she worked through lunch at a hospital, and there was very, very hostile questioning that may be less evident here. But that's my, in theory, 7 minutes. I'll turn on my phone and see if I kept it to 7 minutes.
I'm going to turn to Neil, who's going to talk, among other things, about a pair of death penalty cases. The death penalty was an area where the left, which did very well last term, did not do well, and it gave rise to some of the most heated and bitter statements from the bench, both during the argument and the decision of a lethal injection case called Glossop. Mr. Glossop is set to be executed this afternoon at 4 o'clock, so the court will have one more opportunity to deal with his case. What do you see? And Glossop also gave rise to a dissent from Justice Breyer, joined by Justice Ginsburg, in which they almost 98% announced that they were getting out of the death penalty business. They expressed grave doubts about its constitutionality. And maybe one of the things you might touch on, Neil, is whether that casts some kind of shadow over this year's capital cases.
Okay, great. So thank you. So I'm discussing the death penalty cases and then some others. And I guess the goal here is, it's been said there's a role for, isn't there a role for mediocrity at the court in terms of justices to the court? I think, what I'm doing is there a role for mediocrity in the case selection? These cases are not affirmative action or public unions or things like that. I think they're all linked together simply by the fact I'm arguing them. So with respect to the death penalty cases first, which will be which will be argued in a week, I think criminal law generally is a super interesting area to think about the Roberts Court. I think many of us grew up and thought the Warren Court were really far on the side of criminal defendants in a lot of cases. You could say the same thing about the Roberts Court in a bunch of areas as well. I mean, in fact, last year they had 7 federal criminal cases. They sided against the government in 6 of the 7, including John's case, Alonis, and some others. I mean, big ones. And Fisher versus California, the cell phone Riley case that Jeff Fisher argued, Riley versus California the year before. There's something going on at the court, which is really interesting to think about. And as Adam says, it hasn't really totally trickled down into the death penalty area yet, although I suspect it will. I suspect that is an area in which we will see a major court decision in the next year or two. So these cases that'll be argued on Wednesday, there are 3 of them, and they involve a gruesome set of murders that happened in Kansas in 2000. And a horrible story about a victim surviving only because the bullet, she was shot execution style, the bullet bounced off of her hair clip, and she was therefore saved. So the Carr brothers, Reginald and Jonathan, were charged with capital murder. And in Kansas, you can only receive a death sentence if the jury finds beyond a reasonable doubt the existence of one or more aggravating factors, and that they are outweighed by those aggravators outweigh any mitigating factors found to exist. The jury was instructed about the beyond a reasonable doubt standard for aggravating circumstances, but the jury instructions that Carrs argue were confusing as to the mitigators. It made it look like they say that beyond a reasonable doubt was the standard for the mitigating evidence. The Kansas Supreme Court accepted that argument and said that they thought that the jury instructions were confusing and that they didn't allow the jury to give adequate effect to mitigating evidence. So that's one issue in the cases. The other issue in the cases has to do with joinder. The Carr brothers were tried together. And the Jonathan Carr's mitigating evidence, indeed he said this in the very first day, he said, look, we should have separate trials at the penalty phase because my mitigating evidence is actually aggravating as to my brother Reginald. In particular, Jonathan was saying basically that they had had a horrible upbringing, but that Reggie, his brother, had been a terrible influence on his life, and that it was trying to pin the blame on Reggie for the stuff that happened. And so basically, there was a second prosecutor in the room, the argument goes, and therefore you should have separate trials. Kansas petitioned for certiorari on both of these arguments, as well as on another argument that the Kansas Supreme Court had accepted, the idea that there was a confrontation clause violation at the sentencing phase. Kansas didn't get that granted, and so regardless of what happens in this case, a remand is going to happen. These are very big deals in the state of Kansas. Indeed, it's said that the retention election for the justices may turn in part on these cases. It's a very big political issue in Kansas and an interesting legal issue as well about the contours of the Eighth Amendment. The second case is Montanil versus Board of Trustees. This is a follow-on to the U.S. Air versus McCutcheon case that the court decided 2 years ago. It involves ERISA, which I know is near and dear to all of your hearts. I'm going to keep you awake. But basically, the issue is this. So Montanil has a health benefit plan from his employer, which is the Elevator Association. And the plan says that it has the, quote, right to recover benefits advanced by the plan to a covered person for expenses or losses caused by another party. What does that mean? Well, Montanil gets in a car accident, and he suffers a lot of medical bills right away. and he can't go and get them from the tortfeasor, the guy who ran into him with his car. So he goes and gets them from his own insurance plan. Many of us in this room have done exactly that. So he gets $121,000 from his insurance plan, and then he goes and sues the tortfeasor, and he gets $500,000. He gives $200,000 of that, 40% to his lawyers, and he pays $63,000 to reimburse some other expense costs, and then he goes and spends the rest of the money on who knows what, doesn't reimburse the plan. And so the plan reasonably, sorry, I'll try and be fair and balanced here, but, I'm representing the plan. The plan says, you owe us this money, give it to us. And he goes and spends it, and then says, oh, I'm out of funds, I don't have the ability to give it to you. Some circuits have accepted this argument that you don't have to give the funds because ERISA provides for remedies only at equity, and at equity, the argument goes, you could only attach a judgment to a particular race, to a particular fund, and if the fund is dissipated through whatever action, then you have no remedy. And so the question in the case is really, what do the rules of equity permit? Did the court really, over these series of decisions in ERISA law, basically give a hollow hope to plans and others or not? Last case, Dollar General versus Mississippi Band of Choctaw Indians. This is a case in which Dollar General, a store, operates on an Indian reservation. They operate a store. And in 2003, they agreed to be part of a tribal internship program where young kids on the tribe could go and work at the store for free and learn something and provide some free labor. And one 13-year-old who goes by the name of Doe was horribly sexually harassed at that facility. And the tribe went and excluded the supervisor. And then the parents of the child brought an action against the supervisor and against the store in tribal court, saying this was sex harassment, and they sought money damages. The store, the individual, the supervisor, fell out of the case. The store then went into federal court and said, nope, you can't sue us in tribal court, you can only sue us in federal court. And the question in the case is, what is a limit of tribal court jurisdiction for a store that has voluntarily set up premises on an Indian reservation? The petitioners, represented by Tom Goldstein, a prominent Supreme Court practitioner, have effectively said no civil court adjudicative jurisdiction here, just like criminal law in which you don't subject yourself to tribal courts if you're a non-member. Similarly, you shouldn't subject yourself to civil lawsuits either.
Thank you, Neil. Any comments on the ERISA case? Just kidding. And John is going to continue the discussion of some criminal and capital cases, and I'm curious to start off with what your take on these Kansas cases is.
Well, I'd like to give a background overall, because I think they fit into an overall picture for what the court's doing this term regarding the Eighth Amendment. So far, the court has granted cert on 5 cases that raise Eighth Amendment issues. 4 of them are death penalty cases. 1 of them is a case involving life sentences for juvenile offenders, which increasingly occupies the same space in the court's Eighth Amendment jurisprudence as death penalty cases do. But these are all procedural cases. And I think it's important to understand the background here. So back in the early 70s, in the case of McGautha versus Maryland, the Supreme Court rejected the notion that the Eighth Amendment, that the Due Process Clause was violated by the fact that there are arguably arbitrary results in determining who's going to get the death penalty and who is not. But then a couple years later in Furman versus Georgia, the Supreme Court applied essentially a due process analysis in a highly fractured opinion to basically say that when the procedures that are used in a case that result in the death penalty meet or don't meet some threshold level of arbitrariness, then a punishment might be considered cruel and unusual. So there's this line of death penalty, Eighth Amendment due process cases, which is a separate line of cases from the substantive Eighth Amendment cases, okay? So that's just something to understand by way of background. And again, the cases we're seeing this term I would characterize as procedural cases. The other thing I'd like to note that I think is important background is where the current members of the court seem to be sitting with respect to the death penalty after the case of Glossop versus Gross. And the reason that that's important is in a sense, the procedural Eighth Amendment cases, I think, can be characterized as a kind of proxy war about the death penalty. That is, if you can't challenge it directly as being unconstitutional, maybe you can challenge the procedures that are used that result in the death penalty. And if you get those procedures struck down, you can make it harder to impose capital punishment, and you may reduce the numbers of executions, et cetera. And ultimately, this actually may lead to a kind of whipsaw effect, where if you make execution difficult enough so that it becomes rare enough, the court may then turn and say, the death penalty is an outlier, society has rejected it, it is now unconstitutional. So I think that the existence of the death penalty itself is at stake in these procedural cases. Now, that's also especially clear after Justice Breyer's opinion in Glossop versus Gross. Justice Breyer and Justice Ginsburg in that case essentially opined that the death penalty is unconstitutional not because no one deserves it, not because it is too harsh as an absolute matter, but rather because of procedural problems. That is, because the procedures that are in place lead to arbitrary or unreliable results, they lead to undue delays, et cetera. Justices Breyer and Ginsburg think there's no way to cure that procedurally, and so they think what you need to do is simply get rid of the death penalty, right? So that's, I think that's an important background when we think about this upcoming term. On the other hand, justices, if you sort of count the votes, Justices Sotomayor and Kagan in Glossop versus Gross, although they didn't join the Breyer-Ginsburg opinion, certainly appeared very concerned about the death penalty. They don't have a favorable opinion towards the death penalty, so there are at least 4 votes that are in favor of limiting, if not getting rid of it. On the other hand, Justices Scalia and Alito, again, seem to be engaging in a sort of proxy war about the death penalty. Alito, in upholding lethal injection as a method of execution, imposed a standard that said if you want to challenge the constitutionality of a method of execution, you have to actually propose another method that would be considered constitutionally acceptable, or we won't even hear the case, right? So he's trying to forestall the effort, again, to use procedural challenges or challenges to methods as a way of challenging the death penalty itself. And of course, Justice Scalia said, well, if you want to re-examine our precedents upholding the death penalty, I think we should just re-examine all of our precedents leading back to Trope versus Dulles, a case in the 1950s which announced that the Eighth Amendment depends on the evolving standards of decency that mark the progress of a maturing society. And I can tell you on that, I disagree with Justice Scalia about many things concerning the Eighth Amendment. On that, he's exactly correct. Trope v. Dulles needs to go. Okay, so anyway, so this is the background. These are procedural cases that are in the context of an overall battle about whether the death penalty is constitutional or not, and where procedural cases can be used to make it harder to impose the death penalty and thus make it more likely that it ultimately will be overturned. I'll just take a minute on the specific cases because we have limited time. If people have questions about them, I'm happy to talk about them. Professor Katyal talked about Kansas versus Gleason and Kansas versus Carr, and he did a nice job summarizing them, so I won't repeat. There are several other cases, 2 other cases involving the death penalty. One is Hurst versus Florida, involving the death penalty scheme in the state of Florida. This is actually primarily a Sixth Amendment case. It's a case because the Florida scheme essentially allows the jury to issue an advisory opinion about whether aggravating factors exist so as to make the death penalty appropriate, but then the judge is supposed to make the final decision about whether those factors in fact exist. And so that appears to violate the court's rulings in cases like Apprendi and Ring, which say that if there are facts that allow for an increase in sentence, they need to be determined by the jury and not the judge. And so that's the primary issue in Hurst versus Florida. But there are some Eighth Amendment issues buried there as well. In particular, in that case, the jury was actually informed that its opinion was only advisory in nature, a fact that gives rise to concern that the jury might take its duty to consider mitigating factors less seriously than it should. The procedures also allow the jury to find the existence of aggravating factors by a bare majority, and it does not require the jury to state which aggravating factor it found to support the death penalty. So you could, in theory, have a jury that by a bare majority finds the existence of an aggravating factor where there's no agreement even among that majority as to which aggravating factor exists, right? And so, again, given the heightened procedural requirements surrounding the death penalty under the Eighth Amendment, this could give rise to concerns in the court. The case of Foster versus Chapman is essentially a Batson case, an equal protection case under Batson, where several decades ago, essentially the prosecutor struck 4 African Americans from the jury. The defendant was convicted before an all-white jury and sentenced to death. At the time, the defendant raised a Batson challenge, but the prosecutor was able to come forward with racially neutral justifications for the striking of the jurors, and so the Batson challenge failed. 20 years later, through a Freedom of Information Act request, it was learned that their prosecutors kept lots of notes about the decision to strike these jurors. The notes were very explicitly racial in character, and so there was an attempt on habeas to raise the Batson claim again. At the state court level, this effort had failed, but the Supreme Court has granted cert on it. Now, Batson challenges are hard to win. It's very hard to get a court to revisit it. But again, because of the court's overall disfavoring of the death penalty, there is a chance the court may reverse the state court on this issue. And then finally, there's the case of Montgomery versus Louisiana. And this has to do with whether the Supreme Court's decision in Miller versus Alabama is retroactive in cases that are brought up on habeas. So Miller versus Alabama, the court held that it's unconstitutional to have a mandatory life sentence for offenders who were juveniles at the time they committed the crime. And so Montgomery, the petitioner in this case, is someone who was subjected to a mandatory life sentence for a crime he committed while a juvenile, but his final appeals had run by the time Miller versus Alabama was decided, and so he tried to raise Miller as an issue on habeas. This gives rise to the beloved Teague standards or exceptions to sort of non-retroactivity in habeas cases. And again, I'm not going to bore you with it too much, although you can ask me questions if you like. But basically the question is there a way that we could characterize what happened in Miller versus Alabama as putting some kind of conduct beyond the scope of punishment by the state, in which case it would fall within the substantive exception to non-retroactivity under Teague? Or could you say that there's a procedural deficiency that violates fundamental fairness? And again, these sorts of challenges are very hard to win, especially the procedural challenge under Teague. But because life sentences for juvenile offenders are so heavily disfavored by the court, there is a chance, I think, that the petitioner actually could win in this case because the court in Miller versus Alabama essentially announced that it was disfavoring such sentences so that it may well find the procedure in this case to be fundamentally unfair. And one final point for federal jurisdiction nerds out there, and you know you are one, you don't have to admit it. There are 2 cases that raise questions about federalism and federal jurisdiction, both Montgomery versus Louisiana and I believe, I can't remember whether it's Kansas versus Gleason or Kansas versus Carr. They raise questions about whether a state court decision where it's a little bit unclear whether the decision is based on state law or federal law, in part because the state constitutional law tends to mimic federal constitutional law. Does the Supreme Court have jurisdiction to hear challenges to cases that arise in that fashion? That issue is being briefed in both cases, and so there's some chance, again, for federal jurisdiction nerds out there that you might get some gratification with what the court does in those cases. Thanks.
So the first four panelists have given us a very nice overview of a pretty good term. It's not the term of the century as the last term was, or the term before that, or the term before that, but it's a pretty good term. And so we've talked about the cases already on the docket. Ed's going to tell us about a couple of cases likely to hit the docket, including the first big abortion case since 2007.
Thanks, Adam. Yeah, I've been left with the uncontroversial topics of the HHS contraceptive mandate and abortion. Let me begin with the first, which I think for shorthand we can refer to as the Little Sisters of the Poor cases, the compelling governmental need to force these nuns who have dedicated themselves to lives of chastity and to get the full range of contraceptive benefits. There are 7 pending cert petitions before the Supreme Court in the so-called HHS mandate accommodation cases. More on the way. Most importantly, an Eighth Circuit ruling 2 weeks ago created a circuit split that I think virtually guarantees that the court will grant review of one or more of these cases sometime over the next 4 to 6 weeks. The HHS mandate, as I think most of you know, is the Obama administration rule that generally requires qualifying health care plans to offer the full range of contraceptives, including those that might also operate in an abortifacient manner with no cost sharing to the covered entities. Very briefly, there are 3 categories of employers subject to the mandate. There are so-called exempt entities, which are narrowly defined houses of worship. There are religious nonprofits to which the accommodation, which I'll describe briefly, has been offered. And then there are other entities such as Hobby Lobby who are subject to the mandate directly, or at least who were prior to the Hobby Lobby case. Now, under the Federal Religious Freedom Restoration Act, which is the primary law at issue here, the federal government may substantially burden a person's exercise of religion only if the government can demonstrate that application of the burden to the person is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling governmental interest. So there's a threshold inquiry. Is there a substantial burden imposed on a person? And then there's this strict scrutiny test. In the Hobby Lobby ruling a year ago, the court focused on a challenge brought by a closely held for-profit corporation, and most of the attention in that case was focused on the legal question whether a for-profit corporation is a person capable of exercising religion within the meaning of RFRA. The court, by a 5-4 vote, answered that question, yes. There was also, though, in that case, an important ruling on how one decides whether a burden is substantial or not. And there was also some discussion in that case of the role of the accommodation in determining whether the least restrictive means test had been satisfied. On the accommodation, let me try to give a 30-second version of this incredibly complicated rule. Basically, the so-called accommodation, which again has been offered to religious nonprofits, and after Hobby Lobby has also now been extended to the closely held for-profit corporations, it is a means by which the federal government says, look, we're not going to make you provide this objective to coverage to your employees. We're going to make your insurance company provide it, and just sign this little form and everything will be taken care of. That's a very short version and inadequate, I'm sure, but of what the accommodation involves. Until the Eighth Circuit ruling, the several, maybe 7 or 8 circuit courts that ruled on this question had found that the accommodation did not violate RFRA. Indeed, all of them, I believe, somehow found that the accommodation did not impose a substantial burden on the religious challengers, even though those who didn't comply with it would be subject to big fines. I think a direct violation of the reasoning of Hobby Lobby. The claim here by Little Sisters of the Poor and other challengers is that they're forced to be morally complicit in the provision of coverage they object to, that the accommodation is just a ruse that builds on the existing relationship that the employer had with the insurance company. That whole thing is being used to provide the objective to coverage, and that is a violation of RFRA. That less restrictive means exist, and therefore this accommodation ought to be voided. I think the case ought to be easily decided on the grounds that the Eighth Circuit decided it in favor of the challengers, but this is obviously a very contentious issue where legal doctrine doesn't always clearly govern, and especially given Justice Kennedy's obscure concurring opinion, obscure even by his standards. In the Hobby Lobby case the first time around, I think it's difficult to know, to predict just where things will fall. Okay, abortion. As Adam mentioned, there hasn't been an abortion case before the Supreme Court since the 2007 partial birth abortion ruling. That seems almost certain to change. There are 2 cases in the pipeline now. The first is, the most recent is a Texas abortion case called Whole Women's Health v. Loki, challenge to 2 provisions of the 2013 Texas abortion law. One is a physician admitting privileges requirement, basically a requirement that any physician performing an abortion must have admitting privileges at a hospital within 30 miles of the clinic. The second is a so-called ambulatory surgical centers, or ASC requirement, holding abortion clinics to the same standards that ambulatory surgical centers must meet. I believe it's largely agreed, at least that the immediate effect of applying these rules would be to leave only 7 or 8 abortion clinics in Texas, and that's part of the objection to these regulations. Now, of course, back in 1992, Justice Kennedy, in the joint opinion in Planned Parenthood v. Casey, had famously called the contending sides to end their national division by accepting a common mandate supposedly rooted in the Constitution. I think American citizens have seen better than to abide by his call. But the question here is how his vague and incoherent undue burden standard will apply to these regulations. It's fair to say that is anybody's guess, since I don't think anyone can really make sense of what the undue burden standard means. I'll point out that the Fifth Circuit in this case delivered a defeat to the abortion clinics challenging the regs. Not a total defeat, but a significant defeat. The Fifth Circuit did enjoin portions of the ASC requirement as applied to a particular clinic, and did enjoin enforcement of the admitting privileges requirement against one doctor at another clinic, but it otherwise left the regulations in place. The Supreme Court in June, over 4 dissents, stayed the Fifth Circuit ruling pending certiorari. And again, I think it's likely that you're going to see the votes to grant cert in this case. Very briefly, there's a second case that's actually been sitting up at the Supreme Court for a while, also from the Fifth Circuit, from Mississippi, also involving an admitting privileges provision, in this case obviously of Mississippi law. That law would, in the judgment of the court below, basically effectively close the only abortion clinic in Mississippi. It's a question whether access to an abortion clinic in a neighboring state would suffice. The court there struck down the law. So the question whether the court will choose to grant cert in that case as well, I think it's almost certain it will grant cert in the Texas case. I think it's probable that it will also grant cert in the Mississippi case. My final comment, I'll simply say, is I think here we are, 10 years and 1 day after Chief Justice Roberts swearing in as Chief Justice. We live, for better or worse, and my view is definitely for worse, not in the Roberts court, but in the Kennedy court. I think on issue after issue, we'll continue to see that Justice Kennedy is the deciding vote. So I'll leave it at that.
So we'll turn to your questions in just a second. Let me ask one sort of follow-up, more thematic overview question, maybe starting with John Elwood. Many of us wrote, and many metrics support this view, that the left had a very good year. The left side of the court had a very good year last term. Although Justice Kennedy is all-powerful, the justice most often in the majority was Justice Stephen Breyer at 92%, beating Justice Kennedy by 4%, which is a kind of lunar eclipse of the Supreme Court. John, having heard these good presentations, do you think this liberal trend will continue, or will the empire strike back?
Anytime you're dealing with the Supreme Court, there's always a temptation to try to say that something's a trend and that the line that you have going is going to keep going forever ad infinitum. And I think that it's impossible it's kind of the law of small numbers, that there's going to be weird things like, we have an unusual number of criminal cases this year, which I think is also just a coincidence. I think last year was definitely a good year for the left, and exactly as you say, that this is, although I don't buy into the analogy as someone who's on the right of center, it's definitely, that's Erwin Chemerinsky that last year was Return of the Jedi, and this year is The Empire Strikes Back, which takes the movies out of order, but it is true that it is at least going to be that the kind of cases that are up for next term are cases that the conservatives generally reliably win, or at least if the liberals are going to win next term, it's going to be an even more remarkable term.
I see a microphone back there, so feel free to take your places. Any other thoughts on trends this coming term?
Well, I do agree with what John said. I mean, I do think last term, I think both of, some folks in the room may disagree, but I think both of the big decisions on the Affordable Care Act and same-sex marriage were pretty predictable. This term, I think you could say the same in the other direction with some of the cases that have been talked about. I do think one thing that probably we will see this term and in future terms is really a trend toward more unanimity. It's something the Chief Justice talked about a lot at his confirmation hearings 2 terms ago. They agreed unanimously in 2/3 of all cases. You have to go back to the year 1940 to find another term like that. Ensure that, again, might be something of sampling error with any one term, but I do think it's something that a lot of the justices on the left and right talk about and deeply believe, and I think particularly as they get into some of the hot button issues, like the ones Ed's talking about, I think there'll be a lot of pressure on the other cases to try and have a more unanimous front.
Questions? Yeah, I think if you could go to the microphone, we'll be able to hear you better.
My name is Don Slagle, and this question is about federalism in general. So last term, Justice Thomas had a concurrence in Department of Transportation versus Association of American Railroad that we all read, that made impact and waves towards the administrative state. And this upcoming term, it wasn't mentioned, and I understand that the issue presented is very straightforward in Kingdomware Technology about the VA and the veterans' preferences. My question is this: what's going on in Kingdomware is that the veterans' preference has been that the GAO has said to a veteran who has been injured that, hey, you should have preference based on what the Congress has clearly said. It stated in a law in 2006. And then the VA has come back and said, well, we can set up our own goals and make that discretionary. And so the question is, if you take Justice Thomas's dissent and his request, one of the many requests in his concurrence is that constitutionalism and liberty are tied together, and if we give it to an administrative state, then we're going to lose some of that problem.
Thanks. I think we have the gist of the question. Who would like to tackle it?
Well, I'm happy to give you my 2 cents worth, which I view less as a federalism thing than as increasing skepticism to Chevron, and that the court is nibbling away at
Right.
Chevron and deference to agencies that we saw in the Affordable Care Act case last year, which, as Neil said, they didn't give deference to the Treasury there. There was another case, SmithKline Beecham versus Christopher or whatever, which was kind of another nibble at Chevron. And it does seem that there is, the tide has sort of turned, and there's less likelihood of people deferring to administrative agencies. I think one of the next things that will fall is probably the idea that you defer to an agency's interpretation of its own regulations, the hour deference issue, which I think is prime for overruling, and if you're a lawyer and you're not raising that claim in every case you have in the administrative agencies, you're not doing your job. But that's my 2 cents worth.
Okay, thank you.
I'm sorry. My name is Jim Duholm, unaffiliated. I guess this question would be for Professor Harriet on the issue of whether districts would be created based on eligible voters or total population. It strikes, under the Constitution, the representatives are not, the concept of districts are not created by the Constitution. And obviously, if the representatives were elected at large, those who couldn't vote would have no say in the outcome. So it seems to me one question, at least in this issue, is whether the states, by creating districts, can give those ineligible to vote power which they would not have in elections at large, or they wouldn't have in states, for example, such as Vermont, which only has one representative. Is that an argument that's made, or is that the basis of it? If you understand my question.
I didn't quite get your question here. Could,
Restate it, or?
yeah.
If the elections were at large in each state for all the representatives, the only people who would have an impact on the outcome would be eligible voters. It seems to me that that outcome has changed based, if you argue that the districts can be created based on total population rather than eligible voters, you are changing the results which would apply in an at-large election for all the representatives.
It's true, if we had at-large elections, the whole issue would change here.
It would run into some serious Voting Rights Act problems.
Yeah, we've just spent the last couple of decades trying to get rid of at-large districts, or rather the Civil Rights Division at the Department
Well,
of
but
Justice.
that's a separate issue.
Yeah, absolutely, it's a separate
The
issue.
question is how you count, how you configure the districts to do it based on eligible voters or all people.
Well, that's good food for thought, and thank you for that. Maybe
Okay.
we'll turn to the next question.
My name is Mike Hilder. I have a perhaps related question about the voting rights case, and that is that each state's representation in Congress is based on population. Would a logical result of doing districts by only eligible voters lead to the encouragement of basing the makeup or the number of each state's representatives in the House of Representatives based on eligible voters? And perhaps facetiously, are we going back to the 3/5 compromise in the Constitution?
I don't think we're going back to the 3/5 compromise in the Constitution. Back in Reynolds versus Sims, the case that first started down this road of demanding that districts be equal in some ways, the federal example was brought forth a lot, the notion of, well, do we really need districts to be equal in population, given that states were not equal in population? It was obvious that the framers of the Constitution did not think every state had to have the same population to have the same number of senators. But the court brushed that off with, well, you know, the Constitution was a compromise, and a lot of things had to go into it. You had to get a number of states to sign up for it, and therefore we do things at the federal level very differently from how we do them at the state level. And so the federal analogy hasn't really been taken very far in these cases. I don't have a constitution right in my hands, maybe somebody else does. I think it would preclude the possibility of changing the way we count. It says all persons, I believe, or uses language along those lines for state representation. But since Reynolds versus Sims, we've quite clearly come up with a system under which Supreme Court doctrine on state legislative districts turns out to be very different from the doctrine the Constitution gives us on congressional.
Yes.
Hi, Kathy Roos. Excuse me. Kathy Roos with the Family Research Council. A question about the possible abortion cases. It has always seemed strange to me that the abortion lobby would argue that a regulation that might have the effect of shutting down a certain number of clinics would be unconstitutional because a certain number of clinics might shut down. But if the court takes either of these cases, we're going to hear that argument over and over and over again. And I'm just wondering if there's any other, I mean, abortion is such a different area of law jurisprudentially than anything else. I mean, it's kind of got its own crazy rules. But, and I don't know much about whether there are any other areas that apply this crazy sort of thought. And what I'm thinking is, in Texas, imagine that as this law goes into place and say 6 abortion clinics are left in Texas. What if there was a very enterprising abortion conglomerate, the Lone Star Abortion Technologies, we'll call them LSAT, and they see a business opportunity. Wow, these clinics are closing. So we're going to go to Texas and we're going to open 10 abortion clinics that comply with the the ambulatory surgical center regulations. We know how to do that. We're experts in that. So we're going to Texas. And we find leases and we sign leases and we start, modifying the locations so that we'll be in full compliance. Now, does the court then say, do they look at the leases and say, well, how close are these 10 businesses from becoming up and running? And imagine they're really close, or imagine they've started running. Well, now 6 clinics will close, but 10 will open. So this sounds like the pro-choice regulation, that this is abortion clinic. Or imagine they're up and running, and the day before the court has to decide the case, the abortion clinic staff go on strike. Well, now they're not running at all. And gosh, they're experts in ambulatory center running, and so they can't be replaced because there's no other. So now there's now there's only 2 clinics. Like, isn't it weird that would be part of the legal test? Like what the business practices are or whatever of, I mean, I just don't know if that is used in any other area of the law. I think it's just a completely illegitimate argument, but we're going to hear that and only that if the cases are accepted. So your thoughts, anybody's thoughts?
Well, we'll hear that and a lot more. I mean, there'll be all sorts of false claims that Roe and Casey are in jeopardy. We're counting heads. There's no conceivable prospect of that. Look, I think you're right. The undue burden standard is so vague that anything can count. I think it's really, what the argument really is meant to suggest, or is meant to tie into, I think, is a claim that that there's some sort of serious disproportion between the supposed justifications for the law and its effects. Now, in Mississippi, the Fifth Circuit panel said at the outset of its opinion, the ultimate issue is whether the state of Mississippi can impose a regulation that effectively will close its only abortion clinic. It's a very strange casting of the question. I mean, I think everyone would agree that if you have, say, minimal sanitation requirements, and if no one's going to comply with them, well, that's just the way it is. You don't have to craft your rules in order to make sure you have abortion providers. But again, I think this plays in somewhat differently just in terms of how one assesses, ways, and if you want to take this undue burden, metaphor seriously, the impact of the law as compared to its benefits.
Neil, is that the right way to think about the issue?
Well, I think it's a fascinating question, and I haven't read the law on the record, so I don't know about the law, but just to answer your question, I think it's undoubtedly the case in all sorts of areas of law. Most of my practice is going to the court and saying, look, regulation X is going to interfere with freedom of contract or interfere with the ability of a business to carry out its operations or something like that. That seems to me part and parcel of just general legal argumentation. Here, I think there's a really interesting contrast that the death penalty folks are using compared to abortion, because what they're saying is, you heard about the Glossip case, Justice Alito, you said last year that this is basically death to the death penalty by 1,000 cuts, just, you know, getting rid of this drug, this lethal injection protocol here, that there, but the goal, you said, was to really get abolition, and you didn't like these interim steps because that's the ultimate goal. I think now the abortion folks are going to say the same, make the same argument along the lines you're saying, which is, you know, look, that death by 1,000 cuts rationale works just as much in the abortion context as it does in the death penalty one.
Yeah, death by 1,000 cuts is, I think, a pretty ugly metaphor in this context.
So I've heard, maybe there's a marketplace solution, I'm not sure, but I have heard liberals make the following argument, that if there is a right to keep and bear arms, and a state law closes every gun shop, people might be upset about that.
Well, the law's not closing the gun shop, the law's requiring some gun owners to take some step, and they're refusing to.
It has the effect, and the marketplace doesn't spring into life. Next question.
Hi, my name's Kevin Mooney. I'm with the Heritage Foundation. On the affirmative action case, there are several states that have passed ballot initiatives now outlawing preferential policies, and the court ruled recently that the voters have a right to do this. That seems to suggest there's been an evolution in the direction that Sandra Day O'Connor anticipated, and I'm wondering if that might be impactful in this upcoming case. The court might have a view that since the voters are moving in this direction, that the University of Texas is out of step.
I don't think that'll have much of an impact. I mean, that case out of Michigan, I always thought was, you know, I'm someone who believes in affirmative action in university admissions. I thought that was the craziest theory that a government cannot have affirmative action, that you're constitutionally compelled to have it. I was shocked it got a vote at the U.S. Supreme Court. I think it got 2. But you know, that's a ludicrous proposition that in our democracy that a state can't say we don't want to have affirmative action. So that I don't think matters. I do think, though, that what Gail's talking about the anti-deference stuff combined with, I think, some pretty heartfelt views about race neutrality do suggest this is going to be a tough case for the university. And I should point out that Justice Kagan is recused. There are only 8 justices sitting in the case.
I've actually always thought that in the compelling interest side of strict scrutiny doctrine, the notion that there can be a compelling interest that most Americans think is not even a good reason should have caused the Grutter Court to look at that, the fact that voters were very much against preferential treatment, and say, well, how can this be compelling if most Americans, it's not that they just don't think it's compelling, they don't even think it's a good reason. But the Grutter case is decided already, so that argument is precluded. But I do think the fact that voters in most states very firmly believe that preferential treatment in these cases is bad policy, and they have voted to stop it, is significant. And may well have some influence here.
But Gail, do we have any sense that there are more of these initiatives to come, that there are more states where the voters are going to take this step?
Well, let's see, how many do we have so far? We got California, Washington State, Michigan, Arizona, Nebraska. You know, there are a limited number of states that allow these initiatives. And so there was actually an effort in Florida, but the Florida Supreme Court, I think quite wrongly, decided that it failed the single issue rule. They said you would have to break it down into 10 different initiatives based on race, sex, national origin, you know, each little thing. And as a result, it was not feasible. But
Yes.
I want to ask a broad question, if I could. Neil Katyal mentioned from a couple terms ago the number of unanimous decisions. I wondered about the views of the panel on unanimous decisions, and is it an inherently good thing to increase the number of unanimous decisions? Is something lost there in trying to corral the vote of the 7th, 8th, or 9th justice in terms of coherence or maybe crispness in opinions?
Well, I'll offer some initial thoughts on that. Look, first of all, I don't think there's a heck of a lot that the Chief Justice can do to encourage unanimous opinions. You have, he has, 8 very strong-willed colleagues. There are occasions where you can find a narrower ground for deciding the case that maybe everyone can get on board. In some cases, most cases, you're not going to have that alternative. Obviously, Dean, there are major cases like Brown v. Board, where one would say that it's been argued, I think with some force, that the desire for unanimity there was well motivated and consequential. I tend to the view that, as a rule, the job of the justices is to do their best to express their own view. Sure, one can, if one can find a ground one genuinely believes in, that where there's unanimity, that's fine, but I don't think you should alter your view in order to make a case unanimous. I just don't see what's gained by that, other than perhaps some confusion in the law.
Other thoughts on that? Very good question. As a journalist, I should say I like to have a dissent, much more likely to have quotable language in it.
I'd say sometimes as a lawyer or someone advising parties, having a dissent actually keeps the majority a little more crisp and explicit about their reasoning.
I'll just speak for a second from my ivory tower, since I'm probably the only person here who doesn't practice currently. I find this question, at least possibly, to be a close cousin to the did the left win or did the right win kind of a question, which I just find depressing.
The left one.
But that's not why you find it depressing. You you have neutral principle of depression.
I have a neutral principle of depression, neutral and all-encompassing. But basically, it seems to me the court's job is to try and get it right? They're supposed to get the answer right as a matter of law. And so, when people talk about the power of a unanimous decision, I think that's supposed to be a proxy for getting the answer right? If everyone agrees, then the answer must be right. But of course, if you get everyone to agree by giving up on the right answer, then it seems to me that a unanimous opinion is not something to be sought after, So I'd like it if the court tried to get it right, and that probably would lead to results that the left likes sometimes and the right likes sometimes, and that are unanimous sometimes and are not unanimous sometimes. But again, I live in an ivory tower, so I know that won't happen in the real world anytime soon.
So let me ask one last thematic question, and we'll call it a lunch. Neil, you were saying that the Chief Justice, has made incremental steps and unanimous opinions a goal. And my sense was that, with the exception of 2 decisions, he's been fairly popular among the crowd he emerged from and his usual conservative allies. So I was very surprised to see at the recent Republican debate candidates beating up on the Chief Justice as a mistake, and then to see a TV ad by the Judicial Crisis Network saying, let's not make any more mistakes. And there are 3 pictures there. There's Justice Souter, clearly a Republican who turned out to be a liberal, Justice Kennedy, about whom we've heard a little bit, and the Chief Justice of the United States is one of these 3 emblematic mistakes. Is that the right way to think about the Chief Justice, Ed?
Well, I'll emphasize that I have much higher regard for the Chief Justice than a lot of other conservatives do. I would never class him with Souter or Kennedy, who I think by any sound judicial measure are a million times worse. I think that there are, though, Adam, causes of disappointment beyond 2 cases. I don't know whether you have the 2 Obamacare cases in mind.
I did.
There's the state judicial election case last term. There was the abortion picketing case where he seemed to miss an opportunity to provide a 5th vote for some really strict scrutiny of regulations. There have been others. There is, I think, among some quarters on the right, or certainly in libertarian quarters, an intense hostility to the chief. I don't know, whether that's, I don't share that, and I don't know that it's tactically all that helpful. But it does, I think, highlight, I really think that we need to focus on that what we have is the Kennedy court. There's only so much that any chief could do when you have Kennedy as a 5th vote. Now, obviously, in the first Obamacare case, the 2 seemingly sort of switched positions, so the chief's vote there was decisive. But the focus ought to be, and maybe it is, maybe this is the strategy on what a Republican elected in 2016 will be able to do with the vacancies that can foreseeably open up during that first presidential term and possibly a second thereafter. And I think as folks have recognized on both sides, when you have this sort of 4-1-4 court, and you have the four oldest justices who are, two on the left, Scalia on the right, and Kennedy in the middle, the next president, whether a Democrat or a Republican, is likely to have the opportunity to transform the court markedly in one direction or the other. So I'm guessing, Adam, that some of the talk is really focused on ginning things up politically for 2016.
Any other concluding thoughts on the chief's role?
Well, one thing I'd say is, I do think that sometimes it really depends on the case. So, I don't think and that's what's prompting these ads. I don't think Americans need to read the briefs in the same-sex marriage case to know how they feel. But the Affordable Care Act one, actually, I think you kind of did. I actually, when I first heard about it, thought, wow, this seems like a slam dunk for the challengers. And then you really get into it and you see, wow, it's a lot more complicated than that. And I think one of the real shames and why we're seeing some of this reaction against the chief and so on is Americans don't get to see the court in operation. I mean, this is, I think, John, you probably share this view. Every time I go up there, it's pretty magnificent. These are really good questions. These are super smart, and Americans can't see it, except for the 400 who happen to be there on a given day. And I think that's starting to actually undermine the legitimacy of the court and lead to this sniping. I've been anti-cameras for a long time, but I've ultimately come around because I just think in this democracy, it's our court and the people's court, and they should see it.
All right, unless anyone else wants to bite on that question, please join me in thanking this really terrific panel.